in third position. I noticed that between second position and third position, the positions of the hips relative to each other change.
Correct.
Okay. As far as I know, that wasn't based on, at least you didn't tell me earlier, that it was based on any particular witness statement, testimony, or eyewitness observation. Right?
Some of that was based on common sense.
Okay, I'm sorry. Let's back up. And the common sense is that if you kept Trayvon Martin's figure positioned as he is in second position above George Zimmerman, there's no way that firearm would have been accessible to George Zimmerman. Isn't that what you told me?
In the second position where they were on the sidewalk?
Correct.
Correct.
So you had to move them in third position in order for the George Zimmerman figure to be able to even think about accessing a firearm that would have been carried on his right hip inside his pants. Right?
Correct.
And you didn't do that based on any actual testimony. You said you just did that to be able to put those figures in a particular position.
They were in position relative to each other. The position they were in when Dr. DeMaio mentioned about that, Mr. Martin being shot, and also accessibility of the gun.
Did Dr. DeMaio testify to your knowledge about accessibility of the gun?
That's common sense.
I'm sorry, did he testify about it, or is this just another assumption you're making?
He didn't, I didn't hear his testimony.
In fact, nobody did, as far as you know.
I didn't hear his testimony, so you're asking me about something that I had no knowledge about.
You had no knowledge about it, but you included it in that animation.
The gun had to be accessible.
That's
common sense.
Well, if the gun had to be accessible, if we assume that in fact the figures were positioned as you had placed them. Right?
Correct.
So it's another assumption.
So that the gun is accessible.
Right. If, for example, the testimony was, or a statement was, or some evidence was, that the Trayvon Martin's figures were up at the armpits of the George Zimmerman figure, obviously the gun would in no way be accessible, right?
Not only the gun, the accessibility of the gun, but you're also talking about the position of the of Mr. Martin when he was shot.
So it would be impossible. So you're telling me you couldn't create an animation to fit that scenario.
With him straddling the shoulders of Mr. Zimmerman in position 3, no.
Right.
That's a scenario that wouldn't occur.
And as for position number 3, I think we talked earlier about in order to depict their angles, when you have the angle of the shot being, I think as you put it, 90 degrees earlier, straight in?
Yes, that's what the coroner, also in the coroner's report.
Okay, not left to right or anything like that, straight in. Right?
He mentioned 90 degrees front to back.
Okay.
But he mentioned 90 degrees front to back, but in my conversation with Mr. DeMaio, he mentioned 90 degrees, but slightly from, I believe he said from very slightly left to right.
So you have notes of your conversation with Dr. DeMaio?
Just one.
Just one? Is that the only note you took?
Yes.
Just that about the 90-degree angle or not?
I already knew about the 90-degree angle from the coroner's report, so it wasn't, I didn't have to retain that.
What I'm asking is you just opened up a folder and looked at something. I'm just wondering what it was.
It was just my note on left to right from Dr. DeMaio.
Any other notes you have from Dr. DeMaio?
Just that.
Just that. Okay. So the position in position 3 that we've seen, we talked earlier about how the bodies had to be some distance apart from each other. In other words, the chests of the figures, for example, had to be a distance apart.
Correct.
Because you have to account for not just the clothing differential, right?
Correct.
You have to count for the length of the arms involved, right?
But you don't know what position the arms were in.
Exactly. And you have to count for the length of the gun involved, right?
Well, you're talking about a lot of different variables that I didn't portray in this video.
I understand. So none of them are accounted for here, right?
The main thing that's accounted for with this is Mr. Zimmerman and Mr. Martin, their positions, and the position of Mr. Martin over top of Mr. Zimmerman.
Yes or no, none of those variables I just mentioned are accounted for in any way in that third position animation.
Variables in relation to the bullet trajectory and
The spacing of the bodies, the lengths of the arm, the length of the gun, the distance of the gunshot clothing, all of that. It's not accounted for there because all you want to do is show the position of the bodies, right?
position of the bodies consistent with Dr. Mayo's consultation.
Okay. So no, none of those variables I just mentioned are accounted for in this animation, right?
The variables that you mentioned aren't impossible in this scenario.
Didn't ask if they're not possible. Is that what you said?
Are not impossible.
Okay. Is that a
There
way of
is
telling
space
me?
between Mr. Zimmerman and Mr. Martin in this video.
Is that a way of telling me that they are not depicted here in this animation?
They're in this animation, but they're not expounded to the point that you're talking about.
So I can tell from this animation.
You can
the-
tell.
I can tell from this animation the length of distance between, for example, the gun, the ground, the body of Trayvon Martin. I can tell all that from this animation.
If you use photogrammetry, if you know the measurement of one item, you can figure out the measurement of the other.
I'm not talking about what else I would have to do. I just want to know if I can tell it from this.
The figures in this are to scale. So if you're looking at this scene and you wonder about the size of the individuals involved, they're to scale. So there's nothing that has changed throughout this video in relation to the scale of them.
They're to scale in terms of their height, right?
Correct.
And that's it.
They're to scale in terms of their height and their appearance according to photos that I received.
I thought you told me you didn't take measurements of the other parts of their bodies.
I had coroner's photographs of Mr. Martin.
I'm asking about
So-
other photographs. What I'm asking about is, does this animation show me, can I tell that spacing and those lines just from watching this animation, or do I have to go delving deep into the data that you've compiled underlying that program?
If you knew how to do it, you could tell it from the video.
Let's assume I
Through-
don't, let's assume the judge doesn't, let's assume that the jury doesn't.
That wasn't the purpose of the video. That's why you're not looking at what you're trying to look for.
Thank you.
You're looking for something that's not in the video and expecting something that wasn't the purpose of the video.
It's not there, right?
The purpose of the video isn't to examine the bullet trajectory and the location of the gun. The purpose of the video is to show relative positions from one person to the other and the position of Mr. Martin on top, where he had to be consistent with Dr. DeMaio's testimony when the gun went off.
Would it shock you if Dr. DeMaio might have testified that there was another position possible for those two bodies?
He mentioned that there was a variable of about 2 inches.
That's it?
Correct.
No other questions, Judge?
Thank you. Any redirect? May Mr. Shoemaker be excused?
Yes.
Thank you very much. You're
Thanks.
excused. Any other witnesses from the defense? Any witnesses from the state?
No, Your Honor.
Let's have argument. This is from who?
The state.
Okay.
Are we in a
presentation under Daubert that you want that initial, or are we talking about applicability to this case in this animation now? It seems we've gone one to the other and maybe back.
Yes, we have. The state yesterday had indicated that it was not a Daubert issue, and this morning indicated it was a Daubert issue. So I don't know where the state stands as to the request regarding that.
As I put in the second supplemental motion this morning, I do believe that there needs to be a Daubert analysis or Daubert-Frye analysis, Frye, of course, now being essentially one component of Daubert, so I think we can handle that, as well as a Pierce factor analysis. I think both of those have to apply to this, both the testimony and the animation, so I'm asking for both.
Under Frye and then Daubert, the main consideration with Frye, of course, is that is it generally accepted in the community? I don't think there's been any counter argument from the state that this is a type animation, though it's a new generation, that the underlying foundation of this animation, which is the idea of taking data and incorporating it into an accident reconstruction or an event reconstruction event, has been admitted in courts a lot. It's been by this very witness. He's testified for the last 14 years in this. He's never been disqualified as an expert upon his attempt to have it in. I will acknowledge to the court that I did not present an enormous amount of industry-wide evidence because, quite honestly, I did not realize that it was going to be a contested issue today. However, I think even this expert alone has presented that in his industry, he stays up to the day-to-day or week-to-week information flow concerning the accuracy of the data and software that he uses, that he has been involved in the industry since, I think, '95. And for the past 14 years, he's focused his inquiry and profession on this area, and that he's presented many, many times, and again, has never been excluded. So to the extent of whether or not it is generally accepted, I would suggest that it has been and is. Under this now new sort of Daubert inquiry they look at, I think for the purpose of this inquiry, I think the court needs to look at this and say, even though it has been generally accepted in the past, would it assist here today? And that is sort of a Pierce consideration as well. Will it help this jury in a consideration? I do think that as to that, and we're going to do a sort of a Daubert-Pierce analysis together, because I think what needs to happen is that this court needs to be convinced that it's accurate, and not that it's perfect, but that it is accurate depiction based upon the information available when it was created. It has been, of course, created and recreated several times. With the most recent generation of it was, in fact, based upon some trial testimony, because I perceive that an expert has not only the right but the obligation to make sure that their testimony they're going to present, in this case basically the animation, uses the most up-to-date information available, and that is trial testimony. It's difficult for the state to argue it's not based upon trial testimony and then say that he can't have the trial testimony available to him, even through consultation with counsel, to make sure that it is as accurate as it can be. Within that context, we have taken away some of the frailties of the animation. And that is, it's no longer really an animation, but for the initial animation of the initial strike by Mr. Martin against Mrs. Zimmerman, which came solely from his testimony, but all of that is in evidence now. And
where's the testimony that Mr. Martin is left-handed? Because that animation at the T shows a left-handed punch.
The strike, the injury is to the left side, the right side of Mr. Zimmerman's body, and he had testified that he had gotten struck by Mr. Martin when he first looked up and got struck, and the injury was right here. That's where it's from. And quite honestly, to the extent that the jury has to look at that and say, I think that that is absolutely the most reasonable assumption that they can make. Never did he say he was right-handed. I don't care if he's left-handed or right-handed. As to that fact, he hit him with a left hand, because that's the area of the impact.
Who testified as to that?
Mr. Zimmerman.
He testified he got punched in the face.
And the injury, I'm sorry.
He didn't say from what hand.
That's correct.
Nobody testified that that injury came from a left-handed punch. And Sabrina Fulton testified that Trayvon Martin was right-handed. So I don't have any testimony in the record to show that that was a left-handed punch.
May I give you the
yes, you may.
Insight? Dr. Rao testified. I'm sorry. Yeah, Dr. Rao testified, and she used her She gave us a graphic identification, and she also testified that the injury came across the nose. We have to realize, of course, Mr. Zimmerman facing Mr. Martin, so you know what I'm talking about with the positioning of them. It was Dr. Rao who testified that the punch came in this way. She actually said it went up, which we have contraindications of by Dr. DeMaio, but she testified that the punch came in effect, from left to right because it hit him right here, and she testified that the abrasion was on the inner right side of Mrs. Zimmerman's face caused by the knuckle. So to the extent that you're looking for evidence to support that, certainly there's no evidence to support anything else. Ms. Fulton said, my son is right-handed, but that means that might be the hand you want to use first. I don't know. But the specific evidence from the medical examiner, Dr. Rao, was that it came from the left side and hit Mr. Zimmerman on the right side of his face. So that is what is the basis for the left strike in that animation.
So are you saying that nobody could ever hit somebody with the right hand and cause that injury coming from the left side?
Well, I think that, I tell you what, yes. Now, I don't know if that means that the animation is invalid, but I just have to get it this way by asking Mr. Manchow to stand up for a second. And if he's going to swing at me with his right hand, I suppose if I turn this way, somehow it might come across. So yeah, so yes, it could be. But since we only have Mr. Zimmerman's testimony that they were basically standing in front of each other, that he approached him from behind, Mrs. Zimmerman turned to him, his testimony does say that, reaching down to get his phone, looked up and got hit. That testimony seems to be that they were face to face. Could Mrs. Zimmerman have turned all the way around this way and then Mr. Martin's right hand got him like that? Yeah, that's a possibility. I think that the testimony would suggest, both when we look at Mr. Zimmerman's testimony that he was basically face to face, and Dr. Rao's testimony that the more likely event was a left-hand throw.
I didn't hear her say more likely event it was a left-hand.
No, I just said that.
Okay, you said her testimony was.
Oh, no, I said with her testimony.
Okay.
Then there was my words, it's more likely a left-hand throw. So that was where that part of the animation was created. So we have that part of the animation, and then we took out some of the more concerning parts of what is animation, because after that part of the animation, really what it is still photos or still animations based upon specific testimony. And yes, that was modified based upon John Good saying in his testimony that it happened in certain relation to the 911 call of Ms. Lauer, which is why that was placed in to give context to it. And the main reason for that context is because we know that we have a reverse timing of when...
Let's talk about Ms. Lauer for a second, because in my notes it does not indicate that she saw anything.
No, of course she did not.
And Mr. Schumacher is testifying that the testimony at the T, or the figures at the T, is based upon her, I don't know if it's the first illustration or whatever, it's based upon Ms. Lauer's testimony. She's never said that she saw anything.
No, she said she heard.
Well, but hearing and seeing in the animation is presented by Mr. Schumacher. He said based upon her testimony. If we all only know what she heard and none of us know what she saw, how do you get that position in?
Okay, here's my response. Ms. Lauer testified that she believed that the altercation that she first heard, which was the back, forth, and back conversation, occurred out of her condominium to the left near the T intersection. I can pull up her exact testimony because I think we actually have it, but generally
she testified on that date the bamboo blinds were drawn down. She and her husband were at home around 7 p.m. She was watching TV in the living room. She was on the love seat facing the glass sliding door. Whether it was raining, the glass sliding door was open. Her view to the backyard was obstructed at night by the blind. She heard voices from outside her backyard, couldn't tell the words. The voices were coming from her left, sounded like a loud talking. Voices sounded like the same volume tone, more flustered than confrontational. She muted the TV. She heard scuffling around like sneakers on pavement or grass, combination of pavement and grass. She gradually went to a grunting noise. It gradually turned into grunting. At first it sounded like people standing up, and then sounded like wrestling, rolling on grass. And that's when she decided to call 911 as soon as she heard the scuffling noise. And it took her about 30 seconds to connect to 911. She didn't say she saw anything. She could tell the voices were coming from her left. And she could tell that it got closer because it got louder. First vertical, then they were scuffling around pavement and grass.
She never said she saw anything at all. That animation is placed in that location based upon what she said, where she heard it come from. And I think if you go further in your notes to where the cross-examination occurred, I talked to her about the first. There were the three parts of the conversation, sort of like the red car, blue car, red car was the way I presented it to her. So hopefully those are in your notes as well, because in my conversation with her at that point, I focused her more on the beginning, the initial conversation beginning at the T intersection.
My point being that animation position, Mr. Schumacher said, is based upon Ms. Lauer's testimony.
Of what she heard, where she never saw anything, but she heard it.
Okay, can I see that position again? Oh.
Would they still work?
Yes, it would help.
Okay. Yeah. 1 second, I'll just give you something.
Thank you.
If I might, you see,
Is that the new one?
this is the one you have. If I might approach you.
Please, thank you.
So that's her trial testimony that was.
Can I get this up here
Yes,
so I
ma'am.
can refer back to it? Thank you.
So in any case, that was, you're right, she did not see anything. And yes, in that sense, the particular placement is an estimate on voice. But I think in her cross-examination, when I cross-examined her, she was more specific that it happened in the area of the T intersection. And is it 4 feet away, 6 feet away? But that is a frailty of the animation based upon non-visual testimony. So then the question under this Dauber-Pierce matter is it accurate? And we're talking about that now. The other accuracies of it were limited by, we used John Good's specific recollection as to he testified at trial to these sort of 3 different positionings. That's where we got it from, where he said first they were sort of vertical, then they were sort of, he didn't get the words right, but parallel and on top of the pathway, and then they were further down, and that's where 1, 2, and 3 come from directly. Then he left. And we kept him in that position because there is no other evidence to support changes. Could they have jumped up, gone 10 feet, and run back into the same position? I guess so, but there was no evidence to support anything but what John Good last saw, so we kept it static. And then the positioning was changed slightly, and only, I think, from more like this, which was the mounted position that we saw before, to more like this because of Dr. DeMaio's anticipated testimony that the shot went in, but that the gravity effect of the shirt and the cannon in the shirt and how that would pull it down made sense. Again, I argued to you yesterday when we were talking about this, could it be like this? Yes, now we know from Dr. DeMaio's testimony it might be like this, but that as the bodies go up, then the can pulls it more straight down, and so the idea of having it billowed with gravity means it's more like this. Is it an estimation within that context? I acknowledge that. But at least Dr. DeMeyer's testimony lessened the angle much more so because of the gravitational effect on the cam. And that's quite honestly it for the animation as far as whether or not it's accurate, because that's a premise for whether or not it would assist the trier of fact. And I would suggest that with all of the information that we have in this case, and with the various witnesses, none of whom are direct witnesses except for Mr. Good, but all of whom have almost as vantage point changes to offer to it, that an attempt by the defense to present that in a way that does in fact support the defense presentation of what happened, and we have now, I think, presented an enormous amount of evidence to support that that animation is accurate and would help the trier of fact in presenting the way the defense says the case happened in comport with the facts, that it would in fact assist the trier of fact in trying to get an understanding, a graphic understanding as to how the situation unfolded that night and how things may have ended. So to the extent that Pierce requires that, I think
But the distinction in Pierce is that the state, whether it's the state or defense, is not the distinction. It is that the state intended to introduce that into evidence, and the court ruled that it would be demonstrative only. And it seemed to make a difference in the analysis that the court did based upon that, because it did not go back to the jury as evidence in the case. It was used for demonstrative to assist the expert in their testimony.
I agree that's what the Pierce court did. I did not find that the Pierce court outlined an exclusion for it becoming evidence, just as the state has entered into evidence their timeline. If it is accurate, if it would assist the trier of fact, this court has already, in this case, allowed a presentation to be presented by the state in putting together various facts in a graphic way that I presume that they believe assists the trier of fact in some way that helps their case. That's exactly what an animation is, and there's no reason why it shouldn't be admitted into evidence. I do agree with the court. I think Pierce made a distinction between the two, but I don't know that it was a ruling that I can't imagine it being a ruling to suggest that information cannot be entered as evidence. I think in that case they decided not to. Just to make sure that we follow through the criteria of Pierce, I do think that he was qualified as an expert. He's been qualified in another state and counties before, and that it is certainly applied to the evidence offered at trial. Again, Pierce, while it says that, we know that it's not strictly limited in that the evidence has got to be, the animation's got to be consistent with the evidence. It can't go into some matter that is not otherwise presented to the evidence. It can't show something that for which there is not an evidentiary support. Does it need to be a perfect frame-by-frame rendition of the evidence? I don't believe that Pierce or any other case suggests that it needs to be that. It just needs to be accurate. It needs to fairly depict the circumstances to which it suggests it does. And are there frailties to it? Yes. Is one frailty the fact that if this was in real light, it would be all dark and black? Yes. Is that something that I would then need to explain to the jury, as with every other piece of evidence? You have to take it into context. A gun out of a holster doesn't mean anything when the evidence suggests a gun in a holster? Sure. But that doesn't mean it's a fatal frailty of the evidence. It just simply allows the jury to see what could have been seen by the witnesses, and then they can extrapolate from that to the darkness that we all know existed. So anyway, under that context, I think that we've met Fry now Daubert, and even though Daubert sort of suggests that if otherwise generally accepted in the community, this court can act as, in effect, a gatekeeper to say, I'm not letting that get to this jury without a further foundation of its acceptance and relevance and assistance to the jury, that we have proven that.
Okay, thank you very much. Mr. Montine?
Oriented. and the second of which is Pierce and a companion case from the state of Florida. I'm going to start, if I may, with the Daubert line of cases. First of all, the burden's on the defense to satisfy this court by preponderance of the evidence that the standards required for admission of this type of evidence have been satisfied. In Valenti v. Textron, there's the reference, and I'll refer to court, it's VALENTE, which is the first case in the stack I've given you, a 2013 decision from the United States District Court, Eastern District of New York. But essentially, what I want to refer the court to is the second page of that opinion beginning in Head Note 3, where they set out the sort of Daubert factors. There are a number of them. They are neither exhaustive nor necessarily all-inclusive. However, the ones that have been designated are, number one, whether the theory or technique has been or can be tested. Two, whether it has been subjected to peer review and publication. Three, the technique's known or potential rate of error, and the existence and maintenance of standards controlling the technique's operation. Four, whether a particular technique or theory has gained general acceptance in the relevant scientific community. And I would further posit that then there becomes a question of whether the methodology is either proper for this case or properly applied to this case. In other words, the relationship of the technique to the methods which have been established to be reliable, and then the qualifications of the expert in question. For starters, no witness, or nobody actually, even including this witness, if I understood his testimony correctly, he has never testified before in a criminal courtroom about exactly the sort of thing that he is attempting to testify about here. He has at times put things together or consulted with attorneys, but this is the first time ever with these motion capture suits in conjunction with the other things that he did, that he is attempting, even he, attempting to do this. And nobody else, by his own testimony, in his entire industry, does exactly what he does with the same methodology and same equipment. Now, we could quibble about whether or not all this is a new generation, but that's not what the witness said. What the witness said was, I've never actually testified under circumstances like these before, about circumstances like this before, nor do I believe, since I'm the only one who does any of this, that anybody else has. And he's kind of right. Secondly, as it relates to this, I'm going to refer to the next page of the Valenti opinion, where they go on to quote some additional cases, but at the very beginning, top of that left-hand column, they give you a quote from GE versus Joyner, which was the United States Supreme Court case from 1997. Nothing in either Daubert or the Federal Rules of Evidence requires a district court to admit opinion evidence which is connected to the existing data only by the ipse dixit of the expert. Court may conclude that there's simply too great an analytical gap between the data and the opinion proffered. And I submit that's sort of what's going on here, and we've been having these conversations about the gap between the data of the 911 call vis-a-vis the animation, and the gap between the actual testimony of witnesses. And
Let me interrupt you just
Yes,
because
Your
I
Honor.
interrupted Mr. O'Mara, and I don't mind interrupting people.
Fair is fair.
What would be the difference if this Mr. Schumacher came off the stand and did a drawing of what he considered to be the crime scene investigation? The computer just is assisting that drawing.
Well, I put it this way. It's not exactly just assisting the drawing. This witness couldn't draw a correlation between alleged 911 recordings and the perspective of another witness.
Well, I'm not talking about that. You're talking about his use of the computer program and software. I don't agree at this juncture that that is necessarily falls within the Daubert test, because this witness could make those drawings. The issue of relating the 911 call to the animation is maybe a different argument. But what would prevent the defense from having this witness testify to crime scene reconstruction, get off the stand, take an easel board, make a drawing, and at the same time having that witness playing the 911 call and saying to the witness, could you point to where you believe that these events occurred on there?
We wouldn't.
That's the difference between whether it is a Daubert or it's just an admissibility issue.
The best answer I can give the court is we wouldn't have to be worried about whether or not the drawing is purported to be accurate. The reason that this animation is being asked to be used as substantive evidence, as well as a demonstrative aid, but substantive evidence, we wouldn't have a witness step down, draw something on that easel, submit it as an
Okay,
exhibit.
let me interrupt you again.
Yes, Your Honor.
If the court were to allow it only as a demonstrative evidence, would you have the same argument?
I would have the same argument of it, and I think there are more hurdles to jump. I would still be objecting
For a Daubert determination if it were demonstrative?
I think probably not, because I think Daubert really applies to evidence that's going to be given to the jury. If I'm assured that it's not going to be given to the jury, I think since it wouldn't be testified to, it would be, if we're talking about using it as a demonstrative exhibit, the witness who would do that, Dr. DeMaio, about the position of the bodies and things, has already testified and done, and he didn't need it. He testified quite clearly to his positions on, or his beliefs and opinions about the positions of the bodies and things like that, without even referencing this. He didn't need it. All the other witnesses testified, and they didn't need it. So I would say that I wouldn't necessarily mind if counsel wants to use something sort of like this, I guess, as part of a closing argument, if that's the kind of demonstrative aid we're talking about. But I think my objection to it being a demonstrative aid is, one of the foundational issues in that regard is it necessary for the witness to help explain their opinion? And the only witnesses who would need it have already testified and didn't need it. What we're now talking about, I guess, if we're talking about, for example, the idea that Mr. Shoemaker would come in here and use this as a demonstrative aid to explain his own testimony is only a function of what he's been told by the lawyers and everything else. There's nothing that would be required for the witness testimony to be explained by this. It would simply be a reinterpretation of what has already gone before by that witness. That would be inappropriate from the state's perspective. That's not the use of it. That's not the purpose of a demonstrative exhibit. So that's a long answer to the court's short question, but I think I made that position clear. It depends on sort of demonstrative aid meaning exactly what. If it's used by counsel closing argument, different story and a different analysis altogether. If we're talking about a witness, not Mr. Shoemaker, coming up, playing this thing and telling everybody what he thinks it means, yes, I do have concerns about that. And I think some of them are Daubert related. But he wouldn't have to, if it's not substantive evidence, meet every one of the Daubert prongs. I'll agree with that.
Go ahead.
Okay. There has been no testimony offered or presented so far as would be the defense's burden about the known or potential rate of error, the maintenance of standards, anything about peer review and publication. What we've heard is that they use it for the movies. Great. This is a murder trial. This isn't Casablanca. I mean, we're not talking about, this isn't Iron Man. It's one thing to say, I'm going to strap suits on people and create a complete work of fiction. And it's another to say entirely, I'm going to create something that while it is fiction, I'm saying is a representation of a certain perception of reality. Those are two very different things. So there's been nothing submitted as it relates to whether or not these things satisfied those prongs. Further, I'll continue in the Valenti opinion over to page 6 of the court's opinion. And it's under head note 8. And again, they begin quoting another U.S. Supreme Court case, Kumho-Tyer, 520, that's Kumho. The reliability of the expert's methodology in reaching his conclusions must be evaluated against the specific facts at issue, not generalized theories. And down further on the bottom of that page, in other words, simplifications that are permissible to recreate a collision may not be appropriate to recreate, for example, a non-impact rollover. The reasonableness in general of using a specific methodology does not mean that using the methodology is reasonable to draw a conclusion regarding the particular matter to which the expert testimony was directly relevant. Validation is the process of making sure that despite the simplifications that have been made, the model still accurately predicts the way the object is trying to simulate behaves. Never a more clear illustration of that than, for example, the very beginning of this video, where the evidence and actual testimony is that A, Trayvon Martin is right-handed, where the witness is apparently under the impression that he is in fact left-handed. Again, just going to we want to talk about frailties. This is getting to be so frail it needs traction. The idea that you assume, based upon the location of an injury on the body, that it was struck with a certain thing in a certain manner, is an invalid and unwarranted assumption based on the evidence. It is not hard for a right-handed person to punch someone on the left side of their nose. It requires a half step, a side step, a turning of the head, any number of things. But to sit here and say that it is a punch with the left hand, to depict it graphically and say it is my expert opinion that this is how it happened, without a foundation in the evidence, is exactly what they're talking about when we talk about a lack of validation and the lack of the ability to apply the generalized methodology that we use to make movies to the particular facts in this case.
Well, that's not a methodology issue, that's a fact issue. That's the applying the facts to, inputting the facts into the computer.
And more importantly, creating a result once you have input those facts.
But it's a fact, it's the inputting of the facts that's the issue. It's not the computer is going to do whatever you tell it to do. So if you tell it to do A, B, C, you're going to get that result. If you tell it to do D, E, F, you're going to get a different result.
And if your methodology is to make assumptions that aren't warranted by the evidence, then that is the problem.
But that's not the computer. That's the assumptions being made, the input into the computer.
Agreed.
Okay, thank you.
That is a large problem here as well. Moving to page 8, again, peer review. There's been no testimony about that. Page 9, error rate, unknown, cannot be determined. No testimony about it. Nothing involved in this case. Moving to page 13, the next factor, reliability and relevance. They're talking in here about a particular expert, one of several that were discussed in this case, and I'm going to refer to the right-hand column beginning with the first full paragraph. In this case, that expert merely reiterates without any basis the conclusions that plaintiffs seek to advance in this litigation, which is not proper expert testimony. Expert testimony should not merely reiterate arguments based on inferences that can be drawn by laypersons. Those can properly be advanced by the parties in their summations. That is, again, exactly really what this is it is an attempt to have an expert in graphic design come in here and advance the arguments that are being presented by the defense, both most of his input coming directly from the attorneys. I won't even get into the whole violation of sequestration issue at this point. Or from a 20-minute phone call to a witness who hadn't testified yet, and I think the court has figured out by now, his testimony today isn't exactly what this witness had expected it to be. So when you've got the situation where the expert just comes in and reiterates the arguments, the positions of the bodies, the space that must be between the angles at which they must be, the particular placement of the hips, those are arguments. There's no eyewitness testimony to any of that. Those are arguments that are being advanced by counsel based upon what they claim are inferences. The gun had to be accessible, so it's common sense inference. Well, that's a question for the laypersons on this jury. That is something they should be doing, and that is something counsel can argue to them, but it's not the proper subject of expert testimony. I'll move to, I think it's the third case, and that's the Scordill, Scorddill case, which is a district court opinion from the Eastern District of Louisiana. And again, these are cases that sort of discuss the applicability of Frye factors to situations such as we have here. And it's beginning up on, I think it's page 5 of the copy of the court's opinion, under B, demonstration videos. Beginning in that second paragraph, the standard by which the court determines the admissibility of experimental evidence depends on whether it is being offered to reenact the accident or demonstrate general scientific principles. And here they're talking about experts who went out and sort of conducted a filmed experiment based upon what they believe was their theory of the case and tried to match it closely. Continuing into the next column, if an experiment recreates conditions similar to the accident but does not intend to replicate it, the court will balance the probative value of the evidence against the potential for misunderstanding by the jury, take steps to minimize the misleading effects. Further on down the line, and here we get to sort of a Rule 403 analysis, at the bottom of the last, or the beginning of the last paragraph on the page, the court concludes the video demonstration is likely to confuse and mislead the jury, and its prejudicial effect substantially outweighs its probative value. The idea that you don't have to be exact is correct. I'm not saying that essentially if we don't have a contemporaneous movie made of the incident in this case, that nothing could be advanced as a demonstrative aid, for example. I will quarrel about whether it can be substantive evidence. But that's not really the standard. The idea is if what you've got is not accurate enough, and in this case it's not enough to simply say I'm generally in the vicinity, I'm in some proximity. They are the figures in this case and the positions of the case and the positions of such things as their hips and the length of space between them such that whether firing a gun is possible. Those are all intentional assumptions and all intentional things placed into that animation. They were done with a purpose, and they're not necessarily accurate or based on any actual testimony. The problem is that their arguments masquerading as evidence. The next case is the Salvatore case. That's S-A-L-V-A-T-O-R-E. And I'm particularly talking about page 5 of that opinion. And here again, we're talking about attempted video accident reconstruction. In this case, they talk about the witness themselves, talking about, and there's, I believe it's note 7 there in the left-hand column. With regard to the simulation, the witness in that case, Cusumano, C-U-S-U-M-A-N-O, would not be qualified to provide a video attempting to reconstruct the accident. He's not an accident reconstruction expert or a biomechanics expert, holds no degree in engineering, not qualified to provide an opinion as to the accident reconstruction. Now, I have heard that this witness has testified that he has done reconstructions and been accepted as such before. The bottom line is he's a graphic designer skilled in manipulating software and making movies, but actual reconstruction of events within a crime scene as opposed to reconstructing the parameters and static elements within a crime scene, I would submit, are two very different things. Most significantly, I'll point out to the court that when this witness has testified before, what he said was, I do things like I analogize bullet trajectories where I can take mathematical measurements and draw exact lines and extrapolate the positions of figures from those exact things. Not I put people in positions based on surmises of experts or other witnesses. Down towards the bottom of that column, the last paragraph, there's a higher threshold for admissibility of visual demonstrations that attempt to recreate an accident because they are significantly more likely to confuse the jury than depictions which merely illustrate principles forming an expert's opinion. Again, the expert opinion referenced in this videos are not those of Mr. Shoemaker. They are, if anybody, the only expert opinion is that of Dr. DeMaio, who didn't need it, didn't talk about it, didn't reference it, testified without it. And then continuing in the upper portion of the next column. Thus, for demonstrative evidence closely resembling the actual incident, courts generally require the proponent to establish that the demonstration shares substantial similarity with the accident conditions. By contrast, if a demonstration does not appear to recreate the accident, Rule 403 generally does not require a foundational showing of similarity with the accident conditions. This is being purported, at least, to be a recreation of this crime scene or the events taking place within this crime scene. That being said, the higher standard applies. And if we accept the higher standard applying, the conditions aren't anywhere near close enough. We'll start with the obvious, the lighting. We'll start with the more obvious, the depiction of visual positions, not based on any eyewitness testimony, but based on a 20-minute phone conversation with another witness who sort of described his general theory about how it must have happened. That's not a substantial similarity with the actual conditions. The idea that we have no idea how we go from the T 40 feet down, so we'll just throw an arrow out there, doesn't explain or doesn't say that this is a substantial similarity to condition. What it says is, I don't know. And that's really where it ought to stop. Further, even as it relates to Dr. DeMaio's testimony, his opinion as he testified today was that at the moment of the gunshot, he believed the defendant's statement was consistent with what he understood the physical evidence to be. Not even that it is how it happened, not that it was the only way it could have happened, only that his interpretation of the defendant's statement, that is Dr. DeMaio's interpretation of the defendant's statement, in his opinion, was consistent. Mr. Shoemaker is taking Dr. DeMaio's statement to him about a statement of the defendant that Mr. Shoemaker claims he didn't use in connection with position 3, the position of the shot, at all. He said the only time I used anything this defendant said was as it relates to that first punch. That was what he testified to. So we're, again, talking about sort of relay through relay through relay. That's not the standard for the admissibility of this evidence. Further, I think as it relates to the Daubert issue itself, if this evidence is admitted either as substantive evidence, which I submit it shouldn't even be considered for, or even as a demonstrative exhibit, the court should fashion a significantly strong admonishment to the jury along the lines of this is not pretended to be an accurate depiction of the events. This is a representation of a possible scenario. So even if it's submitted in some form to the jury, they ought to know that this is not being testified as this is how it happened. And nobody should represent that it is, nor should they be confused by any indication that it is. If we were talking about simply some stills created by Mr. Shoemaker showing the location of physical evidence and without figures, probably wouldn't have a problem with it. Even when we start to add figures, as long as the figures aren't purported to have significance in certain ways that they are depicted, in other words, I depict the arms doing certain things even though I don't know how long they really are and whether it would even be possible for them to reach somewhere given a certain angle of a body, like the video depicts them doing, or their hips are in a certain position just because I know that common sense tells me he had to have been able to access the gun without any actual evidence that that's where they were.
I guess that's where Mr. O'Mara, and I need to interrupt you,
Yes, sir.
Mr. Manton.
Yes, Your
Mr. O'Mara, I'm trying to figure out the purpose of the introduction of this animation. I don't see where assisting an expert in testifying as to what happened. Can you respond to that, please?
Yes.
Mr. Mantei, I'll get back with you.
Sure. The animation itself is substantive evidence because just as the state has taken a distillation of other pieces of evidence that they wanted to present to the jury in a format, that's what this is. The reason why it's substantive evidence is that it takes pieces of evidence that exist, various witness statements, and it puts it together in a way that does assist the jury, because what they did is they've taken certain pieces of evidence from Mr. Zimmerman's statement regarding the shot to Dr. Rao's testimony concerning the injuries, and put it in context with everything else that was happening, run in effect a timeline, just as the state has already presented.
But your animation does more than a timeline. Although you voice over the 911 call, the Lauer 911
Yes.
call, the animation does more than a timeline. It's depicting positions of Mr. Martin and Mr. Zimmerman based upon,
John Good's testimony.
Pardon?
John Good's testimony. I mean, in effect, I'll give you an example to compare it to, we have before the jury one of the witnesses, Adam Pollock, mounting me. Was that exactly how Trayvon Martin mounted? No. But it's an example, and it instructs the jury in a visual way how it could occur. We have Ms. Morris prance around the courtroom to give an idea.
but the jury's not taking that back with them into the jury room to play over and over and over again as how a reconstruction of what happened.
Well, they do have the state's compilation exhibit that they put into evidence, which is their timeline on top of their timeline, on top of phone call and whatnot. So they've distilled down.
But they did not interject animation figures into that timeline as to what was happening with the two individuals during those calls.
Certainly, this is an animation depicting what happened during those two individuals based upon John Good's specific positioning of those people.
Well, it's more than that. The animation's depicting a lot more than that, based upon Mr. Schumacher's common sense, based upon an assumption that Trayvon Martin hit Mr. Zimmerman with his left hand,
Yes.
based upon a phone conversation with Dr. DeMaio that was not necessarily his testimony in court. So it does a lot more than that. Dr. DeMaio testified that the position of Trayvon Martin could have been at different angles. He could have been leaning down, or he could have been pulling back. That's my recollection of the testimony. So I need you to respond to
My
that.
understanding of Dr. DeMaio's testimony was in response to them saying he could have been pulling back and George Zimmerman pulling his shirt. Dr. DeMaio said, well, no, that would pull the shirt to one side and then the bullet markings wouldn't match up. So I don't think that Dr. DeMaio gave the alternative suggestion that is now being propounded
Well,
by
I
the
think
state.
Mr.
but-
De La Rionda had asked him, given the fact that Mr. Martin's sweatshirt or hoodie may have been wet, and the fact that he had a full can of, I don't know how many ounces, in his pocket, may determine the position of his body at the time of the shot.
And I think Dr. DeMaio's response was it has to be leaning over because it has to be pulled away 2 to 4 inches. And then Mr. De La Rionda then said to him, well, could it be such that he was trying to back away and George Zimmerman grabbed his shirt with one hand and then shot him? And Dr. DeMaio's response was that would by nature pull these shirts towards one side. Then if you shot and released the shirts, the holes wouldn't match up anymore. So I think Dr. DeMaio specifically countered the suggestion by the state that there was pulling back with a holding onto the hand. But I don't want to re-argue his testimony, that's what I would call it to be. To answer your question, and why it might be substantive evidence as opposed to just being demonstrative evidence, I would suggest that the absolute minimum is certainly a demonstrative tool to be used by me to present the evidence just like I can get up there and draw something myself. I think that's not to presume too much from the court, but I think that's a given, that I could be able to use evidence and demonstrative evidence like this in a closing argument. But whether or not it gets into substantive evidence is, as I said before, what it has taken is a distillation of known facts, and all those facts may be contested. He could contest that it is a left-hand shot. That's fine. That doesn't mean that the presentation, just like we can contest any expert, they could have brought in their animation expert. They could have brought in Dr. Rao and did to say it may have happened some other way. Let's not forget, Dr. Rao's animation, had she had one, would have been 1, 2, 3, 4, right? That's what her animation would have been. Specifically contested by our suggestion as to what happened, but her testimony was her presentation.
But that doesn't go back to the jury room to be played over and over again. That's what I'm grappling with. The difference being that whatever the witnesses testify to, and there's an instruction to the jury about the believability of the witnesses, they can believe some, all, or none of their testimony. And they discuss that, but to have an animation that goes back to the jury room that they can play over and over and over again, like they can the 911 call, that they can the reenactment and those other things, gives a certain weight to something that this court is not particularly certain that comports with the evidence presented at the trial.
I understand the court's concern. I do think that it's a proper distillation of certain pieces of evidence that in and of themselves are unassailed by contradictory testimony.
Do you have any case law to provide me?
No, Your Honor. I rely on Pierce, and I will cite back to the court some of the portions of the case law presented by the state, just to say that once you determine that it is in fact substantially similar, and that's the only determination that needs to be made as far as the admissibility of the evidence, that it is substantially similar to the evidence that has been presented, then it is admissible. And that's about two of the cases. Valente is one of the ones.
Well, both sides are basically agreeing that Pierce is the only case in the state of Florida that relates to computer animation. Is that correct?
I did, I think, provide one other one, which is General Motors versus Porritt, P-O-R-R-I-T-T. I will agree that Pierce is the only criminal case.
Okay, and does the defense agree with that?
Yes, ma'am.
All right, so when I look at the Pierce case, they proffered the computer animation as demonstrative exhibit to help Detective Babcock explain his opinion to the jury and also as substantive evidence. And the trial court ruled that the computer animation would be admissible as a demonstrative exhibit only, and made the particular findings that it did in that case. They cited to trying to look for the citation of this quote in here. It may be People versus McHugh. I'm not sure, but it says, when the results are useful, they should be accepted. When confusing, they should be rejected. And that the presentation be relevant, that it fairly and accurately reflect the oral testimony offered, and that it be an aid to the jury's understanding of the issue. Okay. Any other cases? I'm going to read your cases. There are no other cases by the defense. I understand both arguments. I need to go back here and read it. You're smiling because I've cut you off so many times. Go ahead.
And I promise I'm not going to take you along with this, Judge.
All right, because we have another issue we have to address.
I know. I just want to make a couple points. Number one, Mr. Shoemaker didn't even mention Dr. Rao. He didn't use her at all. Number two, there's an underlying assumption by the defense here that the nose injury arose from the very first punch, which is depicted there in the animation. But they also claim there were many others landed that could equally have done this, so it didn't have to be the left hand at all. Number two, you can't compare this to, Madam Clerk, could I have that timeline? Because the timeline actually was every bit of it, the phone numbers as well as the times, testified to directly by a witness here in the courtroom, and the underlying data That is, the phone records, the numbers, and the connect and disconnect times are likewise also in evidence for the jury. None of the underlying data upon which Mr. Shoemaker relies here are actually physically in evidence before this jury, other than perhaps Ms. Lauer's 911 call. The map of the crime scene isn't what he's testifying about, it's the movement of the figures about within it. None of that is underlying data that is in evidence. Number three, as far as the pullback versus verticality, I just want to recap Dr. DeMaio's testimony in respect as it relates to whether or not the victim could have been in a different position pulling back when he was shot. Dr. DeMaio actually absolutely testified that was possible. Mr. O'Mara's distinction came when he was asked whether the witness, the victim and the shooter could have been actually both standing up vertical when it happened. It is then that he said, well, I think if that was the case, you'd have to be pulling that hoodie. Of course, the hoodie is very baggy in and of itself, but those were the two things. Number three, the Pierce case makes pretty clear, in that case, Detective Babcock, who is the witness that prepared the animation and was testifying about it, would be the equivalent of Dr. DeMaio in this case. It was necessary for that detective to explain his interpretation of how he believed this occurred. That's not Dr. Shoemaker. I want to make that crystal clear. If there was any witness who could use this as a demonstrative exhibit, it was Dr. DeMaio, and he didn't need it. And finally, just the Porritt case, because the conditions of the test in this case were not shown to be substantially similar to those during the actual rollover, the videotape evidence was inadmissible. The closing remark of that, the court cannot use discretion to decide that despite a plain lack of substantial similarity in conditions, nevertheless admit the evidence. So I think the Pierce case makes clear that this has to be accurate, not exact, but accurate. What we're talking about is Mr. Shoemaker's assumptions, not only all not on the record, but he is talking about statements made out of court by an expert to him over the phone, police report information, testimony or statements from witnesses who have not testified, a la Mr. Weinberg, and those sorts of things. All of that is built into that animation. He said that he didn't just base it on actual courtroom testimony because he hasn't heard a word. Hasn't heard a word. Everything Mr. Shoemaker's got, this isn't to discredit him, but it's to point out the frailty of this exhibit, has been filtered through the arguments of counsel.
I
think that's a signal to me, Your Honor.
No,
Thank
I
you.
didn't touch it. The lights automatically go off at a certain time in the courthouse. Is there a way that we could get them back on in the courtroom? If I touch. Okay, we're back on. Okay, so you're finished with your argument. All right, I'm going to reserve ruling on this, and I'll let you know when we reconvene at 8 o'clock in the morning. The next issue is Mr. Connor.